A very good evening to you, and thank you so much for joining us on this edition of Spectrum Extra, live on Radio 1 FM 90, broadcasting from the Central Building, the heart of our city, Kampala, live on its website, www.radio1fm90.com. You click on the icon with the word Listen Live. We are coming to you live on the different radio listening apps, which can be obtained from the apps of your smartphone. Look for any, and as long as you find Radio 1 FM 90, you'll be able to listen to us from anywhere across this globe. Radio 1 is also live on DSTV, where our audio channel is 897. My name is Kenneth Anderson Lukwago, your host, and today, being a Friday, we review the major events of the week. We'll be looking at how Parliament handled the UPDF Amendment Bill. We know that bill finally did pass, creating what they called exceptional circumstances under which civilians can be tried before military courts. This bill also addresses matters to do with the welfare of the army, which has been considered to be very important. At the time of passing this bill, the biggest percentage of opposition MPs actually walked out of the House. There were a few who remained there, including the shadow minister in charge of constitutional affairs, that is the Honorable Jonathan Odur, and others who continued to submit on the bill, hoping that their minority reports would be listened to. Unfortunately, they were knocked back by the majority NRM in the House. Well, the opposition says they are going to go to court to challenge this law. President Yoweri Museveni has congratulated Parliament, saying they saved the country from a big standoff between the army, Parliament, and the judiciary. He advised judges never to enter into army-related matters, and they should focus on handling cases, which are so many. He actually pointed out some of them that they have not conclusively handled. We know human rights defenders have been opposing this bill. The Uganda Law Society says it will join those who are going to court, and the government, through the Attorney General, says they did a good job, and they included even safeguards. One, the UPDF will be required to mark all its items to differentiate them from those of civilians, those that the civilians can actually use. So if you're found with something marked with UPDF, you will automatically be handling something that is a monopoly of the army. So you should stay away from anything engraved with the word UPDF. We know also the chairperson of the military court-martial is going to be a land person at the rank of a high court judge. The appointment will be done in consultation with the Judicial Service Commission. But we also know another safeguard that they are saying is in that new law is the fact that one can appeal to the highest civilian court. Well, we'll be discussing that issue in detail to see if Parliament did good work in that particular regard. At the same time, Parliament also passed a law that is aimed at fostering political dialogue. That's the Political Parties Organizations Amendment Bill 2025. Government, it conditions government-funded political parties to actually commit to democratic principles, which include tolerance, dialogue, and peaceful coexistence. So it also recognizes IPOD as one of the bodies that will be working together with the National Consultative Forum. The National Consultative Forum is that organization that is recognized under the Constitution for all registered political parties. So IPOD's functions will now range from conflict prevention and dispute resolution, and they will be pushing for other things, including what we know as political dialogue. Opposition says this law is not good, especially NUP, who say they are being targeted to be denied funding from taxpayer, and that by pushing them into dialogue with the NRM is some sort of conscription. We have another issue we'll be reflecting on. We saw that meeting between EU diplomats with General Salem Saleh, the coordinator of Operation Wealth Creation in northern Uganda. Of course, the delegates, the EU diplomats expressed concern about human rights issues, including the conduct of the Chief of Defense Forces, General Muhoozi Kainerugaba. And the reaction there, General Saleh said he could apologize on behalf of General Muhoozi, but could not promise to control what he would do, put on X the following time. Well, we saw the reaction of General Muhoozi, who actually told the EU delegation if they feel, sort of caught up here in Uganda, they can actually pack their bags and leave. We'll be discussing that issue in detail to see whether it has any connotation. Just to update you, the army has issued another statement in which they are actually pointing fingers at the ambassador of Germany, who is accused of being engaged in subversive issues, and we'll be looking at the implication of this going forward. I have a panel of four. Let me introduce Dr. James Nkubi, lawyer, military historian, and expert on military law. Good evening, sir. It's a pleasure having you on this panel.
Thank you very much for having me as well. Good evening.
Mr. George Musisi, lawyer and member of the National Unity Platform Party, pundit on legal, human rights, and governance matters. This man is aspiring to be Chira Municipality MP. Good evening, sir. It's a pleasure having you on Spectrum.
Pleasure to be here. Good evening to the listeners, and you should also have added that I'm a former personal assistant to Dr. James.
Hey.
I'm the one who made him what he is.
Are you sure? Hey. Okay, also in studio we have retired Major Awichpola Okwe, Director of External Affairs, NRM Secretariat. He's also a lawyer and a human rights defender. Good evening, sir. It's a pleasure having you on Spectrum Xtra.
Good evening, greetings to our listeners.
And lastly but not least, we have Dr. Sarah Birete, Chief Executive Officer, Center for Constitutional Governance, pundit on human rights and governance matters. It's a pleasure having you, Sarah, on this show.
Thank you so much, and glad to be on this show.
All right, gentlemen and lady, let's start reflecting on some of the key issues, and we want to begin with the manner in which Parliament did handle the UPDF Amendment Bill, and I want to begin with you, retired Major Paula Awich, specifically on this issue. Your party forms the government, and therefore they were in charge of actually pushing this bill in Parliament. What would be your reaction? How has this decision of Parliament been received? We saw the chairman of the party, President Yoweri Museveni, actually saluting Parliament and saying they did an incredible job.
Well, in specific reference to receiving, the receiving of the passing of the bill is from two perspectives, from those who support and from those who don't. Now, from the government side, which government is formed by my party, the ruling party, we were happy, and we thought that it was a job well done. Of course, from those who were opposing the bill, they received with sadness, and we could see that they were not happy. So that is how it was received. But why did we receive it with happiness? One, you will know that this is the overarching development of jurisprudence. This is how a law develops. The cardinal role of the state is to maintain law and order, and they use it in most cases through the police. Now, the society observes the mischiefs in society, the wrongs, and therefore develops a legislative piece to make sure that this wrong, this mischief is stopped. Therefore, in the particular case where the initial bill and actually wanted to address an appellate provision, you remember, it was withdrawn and consolidated into things which included the Supreme Court decisions. But the initial thing was that the then Minister of Defense, Right Honorable Amamba, was my good old boy of military school. In his wisdom, had thought that it was operationalizing the act, the UPDF Act then, by putting regulations to allow appellate provision. Now, the Supreme Court held that he had no power to operationalize an act to create an appellate provision, so it should be passed by an act of Parliament. So the bill was there. But when the Supreme Court came up, he said, fine, now let's withdraw and consolidate. Now, the mischief which was being cured here now was, how do we restrict as a society, as Uganda, people who get equipments that are predominantly the use in the use of the army to commit crimes? It's so neat that it is connected to the action of a crime. For example, it's like when you talk of, say, attempted murder. Do you know that even if you strangle me and my eyes are coming out, it is not attempted murder unless it is accompanied by use of a weapon, a panga or a gun or a spear. Therefore, this law specifically connects actions with the military equipment. And therefore, the mischief here is if you use a military equipment, like you form a brigade of Karamojong to go and raid in a battalion, in a brigade formation, remember? This is not 2-3 thieves who are stealing. And that's why you hear there are 4,000 in jail. Because the cattle rustlers, for example, move in a formation of a brigade. Like if Karamojo was in Kampala, they move up to Liatonde and they raid from there, a brigade, and come back. So, this mischief was being done. Now, for the particular case of the development of jurisprudence, society identifies a wrong, a mischief. A law is passed. Courts challenge like it was challenged. Parliament rectifies it. In each stage, we are moving a step higher. So, it is perfect for the state to identify mischief. It is perfect for the parliament to make a law. It is also perfect for those people to go, those who don't agree, to go to court. But it is also perfect for the state to see the gaps and amend by way of legislation. This is how laws develop. And in that case, we make a better Uganda at any stage. Maybe those who will think even here, they will still want to go to court. They are free. But to me, what I'm saying is that this is a normal transitional processes that we develop jurisprudence in any country. Now, it is also worth knowing that for a safeguard, for those who feel that it's bad to try a civilian, remember this law provides only as a first court of instance. Some people yesterday was talking to a professor who thought that you are hanged there and then in court martial. No, it's just a first court of instance. Then you move to your appellate provision, which you have said. I was there yesterday. I was shocked that the professor thought that you are taken to high court. To court of army court martial. You are hanged. No, it's just a first court of instance. Now, the other point that seems to appear confusing the public is that in the Supreme Court decision, the decision that government is inching on as an exceptional situation was a majority ruling. No, it is in the Windolo main ruling. But also the other judge who mentioned is this lady judge who comes from a family of lawyers, Mugenyi. I know the whole family are lawyers. Mugenyi also said it. So it is not true that the government decided to pick minority decision, a dissenting view. No, this was a majority decision. Therefore, we feel that we are not in divergence, we are not in contravention of Article 92, which prohibits making a legislation to defeat a court ruling. So we feel we are pretty safe because we followed what was in a majority decision read by the Chief Justice. And we have tried to meet all the provisions there is in. If there is anything missing, then that would be a human error and can be amended or provided by way of amendment. So we are happy with this, what has taken place. All right. And we thought it would make the society a better Uganda.
All right. Let's now move on to Dr. Sarah Birete. Dr. Sarah Birete, very quickly, you heard from Major Paula Awich there explaining how satisfied they are. He also talks about what some people have been calling the safeguard measures. That maybe the fears that you had as human rights defenders that this law will be for just, throwing people in the military court martial and then jailing them is not actually true. They did a good job.
Well, first of all, I want to state that the bill has a bit of good components regarding the welfare of the officers and, in the UPDF.
Officers and men.
Yes, the medical provisions, the pension provisions, and no citizen is against that. I wish the bill had restricted itself to matters UPDF and left citizens alone. Everybody would be having the same feeling like my neighbor and friend, Afanda Wichi. So what are the contestable issues in the bill? First is the elephant in the room, the trial of civilians in military courts. It's important for Ugandans to know or recall that after the January 31st decision, the president wrote an angry letter on his Buru letters of State House, telling the judges they don't have power, the people have power, the judges are not in charge of this country. And very ridiculous for a head of state who should have respect for the doctrine of separation of powers and the Constitution. And even if you disagree with the ruling, you know, he went ahead to attack the judges and even single out to the two dissenting judges and thank them in that angry letter. And then this was followed by verbal attacks by both the president, who is commander-in-chief, and his son, who is CDF, against the judges. The same celebration yesterday while in Ruero, he did again refer to the judges. I thank the MPs. You know, these judges had messed us. It is wrong for a president to attack members of the other arm of government. You can disagree, but you must disagree respectfully and respect the Constitution and respect the work of the judges. So this has been lacking in this particular decision of court. So this is the background through which the NRM now enacted the proposed bills through Attorney General and the other legislative departments. But the caucus met, I think, about twice or thrice before the bill was tabled on the same UPDF bill. The last meeting, when the caucus was drawn from the drafting committee in Munyonyo, the MPs are clear, those who attended the caucus. The president told them, I don't want any alterations to that law. You will either do my work or I will find people who will do the work. That is a bit of intimidation. And unfortunately, the NRM MPs maybe could not explain themselves. I don't know why. So this is the background. So what are the issues? Supreme Court outlawed provisions regarding trial of civilians in military courts. In the Principal Act, these were sections 117 and 119 G something. Outlawed. And the majority judgment, 5-2, said there shouldn't be any trial of civilians in military courts except under exceptional circumstances. And that was in the advisory orders. Justice Owinyedoro went ahead to explain what that meant. And he says these exceptional circumstances must be proven on a case-by-case basis. He further goes ahead, and I want to invite Afandawich to read that judgment in detail, not piecemeal. He further goes ahead in that judgment to say that the normal exceptional circumstances would be in a situation of war where civilian courts are unable to meet. Now the NRM goes under the former repealed sections and edits in the subheading exceptional circumstances, forgetting the definition of that. Even the UN describes what exceptional circumstances mean. They only included lockdown during COVID. So any lawyer should be knowing these are basic issues. You don't define exceptional circumstances in law. They are determined on a case-by-case basis and with evidence. So when they go ahead in that section, subheading, they just add exceptional circumstances. They even went ahead to expand the offenses that the Principal Act had for trial of civilians. And they are deceiving people that they are implementing Supreme Court judgment. Which judgment? That judgment is written, publicized, and it's very clear. So we shouldn't put words in that judgment that the judges didn't say.
All right.
So the other issues, one is, as I conclude, the issue of course, competence, independence, and impartiality of the judges. The bill handles the competence aspect, but also in a twisted manner. The judgment would have assumed that these judges of military courts are recruited through Judicial Service Commission. But now they are saying on the what? In consultation. I don't know, what does this consultation mean? It's not defined. So even the Judicial Service Commission has been drawn on periphery.
Mm.
Then the issue of at least military stores, now they have to be branded, those belonging to UPDF. Not this random issue of picking NUP supporters, claiming the red overalls are military stores.
All right, Spectrum Xtra on Radio 1 FM 90. Let's go for a break now. When we return, there are two more panelists to weigh in and share their views about what Parliament churned out. Was it the right thing? Does it have the safeguards that many people were looking for? Stay tuned to Radio 1 FM 90. Keep your comments coming via the WhatsApp line 0703 090 090. Well, we're glad that you're still with us on Spectrum Xtra, live on Radio 1 FM 90. My name is Kenneth Anderson Lukwago, your host. Today we have a panel of four: retired Major Awich Paula Okwir, Director of External Affairs, NRM Secretariat, lawyer and human rights defender; Dr. Sarah Birete, Executive Director, Center for Constitutional Governance, pundit on human rights and governance issues; Mr. George Musisi, lawyer and member of the National Unity Platform Party. He's also aspiring for as Kira Municipality MP. And then coming now on the microphone is Dr. James Nkubi. He's a lawyer, military historian, and expert on military law. Now, Dr. Nkubi, we've heard from retired Major Awich. We've also heard from Dr. Sarah Birete. And one issue that keeps coming out is the definition of what they call exceptional circumstances, because that's the window through which a civilian will be arraigned before the military court-martial. Can we have your take, first of all, generally speaking, as an expert in this area, military law and military history? What do you think about the decision of the Ugandan Parliament and the government generally to once again take civilians back to military courts?
Well, thank you, and I want to appreciate Major as well, because he has set the pace of discourse and probably contradiction. And then, of course, Dr. Sarah. Now, for me, really, on a bigger spectrum, this law was threefold, if I may. In essence, we need to ask on a bigger platform whether it is reformist of the UPDF as an institution, especially if you look at the other articles, and Sarah has hinted on that. And why I'm interested on whether it is reformist in the UPDF, because we all know world over, especially in Africa, that the military is a reflection of a state. The diversities in the military in terms of ethnicity, the education, the acumen, it is. And professionalism, technology, most of these things begin with the military. So for me, one of the questions I had was, okay, when you look at the entire law, how reformist is it of UPDF? How professionalizing is it of the UPDF? And how restrictionist is it of recoiling the UPDF to go in spaces it's not supposed to be going in? Because as we all know here, that you can actually use a law to open a space you're not supposed to be in. Historically, used that, using the economic tribunal during the holding times. We know that. So when you look at the good, which, by the way, is the biggest percentage in this law, it is being overshadowed by a bad, which on all accounts, people have every legitimate issue or question to bring up because of one, history, and the immediate past of how these sections that are now back have been used. So there are legitimate concerns that have peculiar case testimonies to them. Two is, how does this law help us to develop as a country? Because as we all know, again, that law is a creature of state formation. When you give too much power to the UPDF to enter into civilian life, to enter actually, or to militarize, if I may, the justice system, to what extent are you contributing to a justice system growth of the country? And I'm talking about this in the context particularly of wanting to brand our country as pacified and wanting to brand our country as inclusive and welcoming. If a person wants to come for tourism, and there's this narrative that even when you're a civilian, you can be a subject of military law, even if he has not had the opportunity to read or whatever, there could be questions. So that bit of state formation also becomes important. Now, the question of exceptionalities. And Dr. Sarah has hinted on that why, first of all, why exceptionalities? Because the Supreme Court was very clear that we are looking at the military court as a predominantly a disciplinary institution. Internal discipline, internal cohesion, internal obedience of the forces to the law. In essence, professionalizing the institution. So when it introduces exceptionalities, or it hinted on exceptionalities, we must appreciate the general rule. The court was saying that you're not supposed to be where you're going. You're not supposed to be there. You're supposed to look internally within yourselves and make yourselves better to better serve the country. However, you can go beyond the environs of your jurisdiction under exceptional circumstances. Now, and this is where we are at. What is exceptional? And should exceptional be legislated, or should exceptional be left to the vagaries of the day as things change? I want to appreciate, and I think they wanted the bit of exceptional to be so ambiguous and amorphous that you can bring in anything, okay? And we know that a law that is so ambiguous and expansive and elastic cannot stand, because practically you can incorporate and conscript everyone into such a situation. Now, so in as far as we are legislating exceptionalities and not leaving them to the order of the day, that's questionable. Let's go on this point of exceptional. World over, and we have got judicial decisions that have tried to expound on this matter. And the debate, which again was also hinted on by the Chief Justice in his the main decision, was the argument of breakdown of law, of rule of law. I have been in the break telling Major here that if this bill had come 25 years ago, when Karamoja was down in rule of law, if it had come 35 years ago when we had a post-conflict northern Uganda, actually reigning conflict in northern Uganda, where civilian rule was almost a no-go, where the civilian courts had broken down, it could qualify to emerge as an exceptional case, geographical in nature, because we have a breakdown in civil law, in civil courts. You technically, tactfully, legally, you would want to bring in the military court, because the circumstances at the time could speak to exceptionality in as far as there has been a breakdown in civil courts and rule of law has to be enforced. All of us, again, who have lived in this country long enough, we know that at one time there was almost no police in northern Uganda. There was no police in Karamoja, save for the as to the anti-stock unit. So now when this system, the current government, the current UPDF delights in pacifying the country, delights in the argument, the narrative, which has some credence to it, that look, we are somewhat progressing towards a peaceful country. It becomes extremely difficult to explain an exceptionality of breakdown of rule of law, of breakdown of civil courts. Because right now in this country, if we go with the argument that all regions are almost tending towards pacification, you don't have an argument of exceptionality to invoke the military court.
Let me just ask you this. Do you see exceptional circumstances, for instance, in Karamoja, where we are told there are so many people with guns? We're actually told that even some judicial officers are afraid to operate from there. Is that an exceptional situation?
Karamoja has remained a thorn in the neck for our country. Now, when you see that there was an invocation of the crime or the offense of cattle rustling, first of all, that alone gives the law a geographical focus. Because certainly there's no cattle rustling in Kayunga or in Kawempe or in Ikira, where George is standing. So geographically, you can even get an appreciation of where this law is going to focus on. I mean, the people is going to probably, not probably, that are going to be a focus, the cattle rustling. But again, we remember historically that the government had adopted demobilization, disarmament and rehabilitation agenda in Karamoja. it had adopted political solutions to what initially it had defined as a military problem in Karamoja. How I wish that it goes back to the original agenda, which was the deconstruction of Karamoja then as a military hotspot, to the inclusion of it being defined as a political problem then, as a question of marginalization, bringing in services. The mindset, by the way, came to bear with the road construction. You remember at one time even the First Lady was a state minister for Karamoja. With all these
she was actually full cabinet minister.
With all these dynamics of new education systems, you could see a tackling that was holistic in nature, that was debunking militarism as the ultimate solution to Karamoja, but the inculcation of all the other holistics. Now, first of all, we can't wish away the cattle rustling. Two, we can't wish away that cattle rustling is actually, they are armed. Okay? Three, we may want to question, therefore, that is there sufficient force on ground, like, for example, the police, to counter this? Initially, you need to appreciate the history of ASTU. The history of ASTU was let's upgrade a unit within police that could equate the force that the Kasolas were deploying. It was a tactical move to take away the military from being deployed in Karamoja, to leave Karamoja to remain an internal issue being handled by police, by a particular specially trained unit within the police, ASTU. Some of us hold the view that ASTU should be strengthened, and the military, keeping a gatekeeping agenda in terms of pacifying that region. Now, when you say, and of course, most people who are not alive to what has been happening in Karamoja, there has been this narrative that that this law is only here, or we are looking at civilians here in Kampala. But listeners would want to appreciate the fact that actually the military courts have been even more emphasized and forceful in Karamoja when you consider the number of people who are there. But on a last mark on this, Ken,
very quickly,
or particularly on, for me, the progress, I think we also missed the point. Georgie has been in military court here. I mean, you could think he's an inmate.
We are going to hear from him.
Hopefully, yeah, he doesn't become an inmate soon. But he can tell you that over and above us talking about the military court in the context of justice for civilians, there was also underlying causes for the military officers within the military courts. Officers who were actually undergoing trial within there. And if you look at that case of the gentleman who was running to the Court of Appeal, it was a plea that, look, can you also look in our side here, we as serving officers, we need a refined system. That's why, for me, I look at the progression that has been done in terms of what Sarah said of competence. The one that you're bringing in a lawyer, or you bring in someone who knows the law to run the show, the chairperson to be a high court,
a level of the high court judge.
So we need also to appreciate that from the context of the internal military officers, who are the primaries and who are supposed to be anyway the only primary subjects of the military court. For me, I think that probably these changes that we have seen in terms of competence and creation, we may see some progression towards them having justice over and above the debate of civilians in court. All
right. Thank you very much, Dr. Nkubi. Spectrum X on Radio 1 FM 90. Now, let's hear from you, Mr. George Musisi, from the explanation given by Mr. Nkubi, Mr. George Musisi. It seems you're more experienced with military courts by virtue of being a lawyer to a number of people who have been arraigned there. What's your
and the perspective?
And probably you might be an inmate.
Like each of us here
in the days to come. I don't know whether that's true. What's your take? How did you receive this decision by Parliament as a political party, but even as a lawyer?
Of course, I received it with consternation, but it was not surprising because the clouds had gathered for a while. And we read from the time of the Supreme Court decision, the strong voices from the military were that they were against the decision. In fact, even if you look at the manner in which the bill was processed and passed, it was clear that it had only one outcome. It was not brought to Parliament for debate, it was brought to be passed. In fact, in her instruction, the presiding office of the House, when she was sending the bill to the committee stage, she said, I don't want politics with this bill, I want it brought back here and we pass it.
And we saw her yesterday in Bukede actually celebrating. One of the things she said, she was happy that the law had been passed because the Karamojongs were disturbing
of course,
the
that
Teso
is,
sub-region.
that is a smokescreen. So how did we receive it? First of all, many people, when talking about this bill, and I heard it from Major Apola's statement, they talk about Karamoja, they talk about being found with meat equipment. You've rightly said that I've represented, and the last 4 years I've represented over 400 people, civilians, no soldiers. And none of them has been found in possession of a weapon. All of them, it has been a cape, a t-shirt. Some, when they are more creative, they put a peep in the house for purposes of bringing you within the ambit of the military court. And
What do you mean they put a peep?
of course, they come and they arrest you, keep you for 1 week, then they say we're taking you to your home for a search. Then they say, many of us here, apart from you, Anderson, are lawyers, and even you a lawyer by virtue of
Osmosis.
hobnobbing with lawyers a lot. But we know how a search is conducted. When you're conducting a search, the person, the accused, the suspect, should be present with a person of their choice, maybe a lawyer, maybe a next of kin. But you go to one room and then an officer comes and says, like it happened in the case of Achireo. When they're in this room, an officer says, we found this in the bedroom. Let me give another funny one, where 101 people on the campaign team of the NUP presidential candidate in 2021 were arrested, and they were all in state custody. Then they were arraigned in the court-martial, and they were said they were found in possession of 4 bullets, which were found in the home of one of them in Makerere. Now, all the 48 were in state custody in Masaka, over 130 kilometers from Makerere. And they say they have found 4 bullets in the home of one of them. And that is the reason why they were in custody for 6 months.
But one of them?
Yes, even the one who was allegedly found with the bullets was in Masaka.
How did they stone the case of was stoned?
Of course, that one is in the High Court. It's in the Senate. The treasons. It's still pending trial. But I'm talking about how ridiculous. Even if, by the way, 48 people, how can 48 people be found in possession of 4 bullets? How big are those bullets that they can be carried by 48 people? Is it like a missile?
Maybe
Major Apollo here was more how bullets which can be carried by 48 people were they? So
maybe the ingredients of the case were that those people were actually organized.
No, I'm telling you, of course, lawyers know that something being found in possession, it's a matter of fact. It's either physical possession or constructive possession. The constructive could be I'm the owner of that home. The physical is that, yes, you are found in. So there's no other ways around it. Now, if you look at this bill, and Sarah has rightly said, that the judgment of the Supreme Court, and I disagree with Major Apollo when he says the majority decision. No, there's no such a thing as a majority decision. In fact, most of the judges, I think 6 out of the 7, were against any form of trial of a civilian in court-martial. However, they said the exceptional circumstances, and the bill purports to talk about exceptional circumstances, because it says in its objectives that it's intended to try civilians in exceptional circumstances. One, it doesn't define exceptional circumstances, but then, if you look at it, it actually opens a wider window for trial of civilians than even prior to the 31st Covers Guruka Supreme Court decision. So it's actually creating what the Supreme Court condemned, a parallel judicial system. The Constitution, and you know, Anderson, when we are reading court judgments, especially those pertaining to interpretation of the Constitution, they should be read purposefully, not like a fanciful novel or a newspaper story. They are read in light of the constitutional provisions and what was the purpose. The purpose, the Supreme Court was saying, administration of justice in this country is in the hands of the judiciary. That is what even Covers Guruka, the Constitutional Court, said. Now, military courts, the reason why they were even saying that, they can, in fact, even for soldiers, if a soldier walks out of here and shoots people on the streets of Kampala, and even that one can be charged in civilian courts.
For murder.
For murder, because, yes, because what he has done is already provided for as an offense. So, ordinarily military court should be restricted to service offences, and those offences where, for instance, the civil courts have no jurisdiction or there are no courts and things like that. Now, there are of course other good things about the bill. I want to talk about those ones, the issues of pension, welfare, and blah blah blah. The contentious issue, the elephant in the room, is one, constitution of those courts, and then trial of civilians. The reason why we've had military courts forever, since the 95 Constitution, it established them. There have been court martials have been there. The reason why there has been an uproar is because there has been a strong use of that court to settle political scores. It started in 2005-6. Remember when our learned colleagues Kale Balaka and Elias Lukwago were even convicted in that sham court, chaired by the deceased General Tumwine, and Dr. Vesije had been taken there on charges where there was even facing parallel charges in the High Court. We saw General Tumukonde prosecuted because of some comments he had made on CBS. And then, in 2019, it reached an all-time high where we saw hundreds of civilians being taken there on seemingly political reasons. I told you, all the over 400 we've represented, none of them has gone through a full trial, where they say that the state has brought witnesses and you've been convicted on the strength of the state's evidence. None.
All right.
So the intention of this law is one meant to bring back civilians before, but then there's been another question that why are civilians so worried of being tried? One is because of how that court has been used. I've already given you some examples.
If you know you are not going to get involved in issues that are a monopoly of the UPDF,
Yes.
why are you worried?
The
That's
reason why the constitutional provision on fair hearing, and that takes me to the other bitter pill about this on the independence. They purported to put a line that the courts shall be independent. Now, when you're looking at judicial independence, yes, they put a line that yet independence. One time, Ugandans lawmakers were arguing and said we should say independent commission as if the word makes you independent. Independence is in construction and real. Judicial independence world over is one, in appointment, two, security of tenure, three, other issues like emoluments. If you look at appointment, we're already grappling with the appointment of judicial officers in this constitution, by the way. But now they're saying they shall be appointed by the High Command, meaning there's still a fusion. You're appointed by the High Command, appoints you in consultation with the Judicial Service Commission. How is that consultation done? If I consult you, Anderson, am I bound to follow that advice? And then no other, you don't go to Parliament, you don't do anything. So then they say they will be on the court martial for 3 years, meaning after the 3 years, they go back, they revert to the army, the ordinary, and they're under the command. We're already grappling with the issue of acting justices, where people say, if I'm still an acting judge, I should toe the line. Now, a court martial chairperson, who they say is not under the command during the 3 years, but you're going to go back after the 3 years. They have created something called a disciplinary something for the court martial, which can discipline, which is also in their control. So a court martial has a whip, a person who is whipping it. So it's perfunctory, it's a smoke screen. And of course, I hope you give us some time to talk about the process. All right. Because that's another story.
Spectrum X on Radio 1 FM 90. Let's go back to Mr. Pola Awich to get his quick response before we go for a break. Major Awich, you kick-started this discussion, and you've heard from your colleagues across the table responding to some of the issues you put across. And there's that issue of exceptional circumstances, which seems to be the window through which the government wants civilians tried before the military court martials. Can you help us to understand it from this law, from the argument you earlier made? They seem to suggest that that's not what the Chief Justice meant.
Well, exception, first of all, should be read in juxtaposition with what is agreed that no civilian should be tried. That one is a position. Even government accepts it. We do accept that Supreme Court ruled that civilians should not be tried in court martial. Now, our colleagues don't want to accept that the same court gave exception. But when you argue and put out emphatically that the majority ruled that civilians should not be tried in a court martial, it's like the government or the military is saying the contrary. No. They're not saying the contrary.
They are saying the exceptional circumstances referenced by the Supreme Court are not the ones reflected in the bill. That's what they are saying.
No. Sarah was asking me to read. I read it. The exceptional situations were referred to as exceptions. There was an attempt to illustrate, but that was not exhaustive. There was the attempt to illustrate that, for example, or like the example they cited, but those were just illustrated provisions by the court.
All right. Let me tell you my understanding of exceptional circumstances. Exceptional in the sense that the courts, the civil courts, the normal courts that we know, are not in position to try that particular civilian. Therefore, the army can do that.
That is one exception. The exception here is that, like Doctor says, there's a general rule. Now, out of the general rule, then there's for example, the general rule, you know, the lawyers like using general rules so much. For example, the general rule is that Rugambo is not admissible in court. You can't go to court and say hearsay that I had, except a situation where you hear, say in the other room, when I'm with Peter and you hear Peter saying, "A witch, you are killing me," and you go and find the person in a pool of blood, you said, "I heard." Therefore, that is the exception to the general rule of inadmissibility of hearsay. Now, the general rule here is that civilians should not be tried. Accepted. Government accepts it, UPDF accepts it. Now, our friends see, but exceptions in this case is that the state, which has a duty to maintain law and order, thinks it wise that the exception that it sees fit is the one that was put in the law.
But the state should act within the law. Even if it wants to see something done, it should act within the law.
It is now making the law. So acting within the law or outside the law would mean that it is acting in contravention of the Supreme Court ruling, which is not the case.
I'm referring to the Constitution, not specifically only the
the Supreme Court was interpreting the Constitution. Yes. So the exception is as picked by the state.
Okay.
Now, the other thing that I could say in line with this is
finally.
Finally, I have so many things.
We need to go for a break.
Final is that my colleagues seem to say we should leave exceptions open. That leave exceptions open. This would be very dangerous because it is now zeroed on. It is now zero. Why would you leave it open? Right. That a law which is left open is very dangerous. Right. And that's why you even think by zeroing down to marking military equipments is zeroing, not leaving it open. You want me to stop here?
All right. Spectrum Xtra on Radio 1 FM 19.
Let's go for because I still have things
Let's go for a break now. When we return, I'll give you an opportunity to actually wind up. Stay tuned, Radio 1 FM 19. Keep your comments coming via the WhatsApp line 0703 090 090. We continue after this break. All right, we're glad that you're still with us on Spectrum Xtra live on Radio 1 FM 90, reviewing the major events of the week. The panel with Dr. Sarah Birete, Dr. James Nkubi, Mr. George Musisi, and retired Major Paula Awich.
At least everyone on the show has a title. You should give me something better than Mr.
Incoming MP.
Okay.
Aspiring
no, you can give
something
me
like
doctor
that.
just for passing the show.
Potential court martial. What?
Chairperson. Chairperson now.
But they said you must be serving officer.
For serving officer.
You'll have to go. They'll give you a rank.
Just stick to ADC, to Dr. Nkubi.
All right. Let's go back to retired Major Awich. He had some few points conclude in response to what had been said, and then we take a round, especially to see the best way forward. Should we leave this matter to the court? Because there are some people who are saying they are going to the courts of law to actually seek an interpretation. But let's hear from Major
But with the previous sense of humor that we were sharing about counsel's position in court martial, I don't think it has changed. The position was that the court martial appeal court is chaired by a civilian.
It was removed now, I think.
Sure.
They now say you must be serving. You must be a serving.
No, there's a general court martial.
Yes.
Then there's appeal
No,
from that.
it was removed.
Oh,
The law removes the court martial appeals court.
And
So after
and
general
says
court martial, you appeal to the court of appeal.
you can appeal to the normal civilian court.
So you miss out.
You miss
You miss out.
It would have been a big fish, eh?
Mm.
All right.
So
Let's hear from-
I was still on the question of leaving exceptions open. That would be dangerous.
Mm.
And that is why I'm happy that the law, now the current law, closed out on exceptions. And that is, as the Supreme Court recommended, you do not, if you want to leave exception relative and circumstantial, that you will wait at one point, then you say, oh, this is exceptions that we should apply a court martial. I mean, a trial of civilian in a court martial. Then you wait for another, oh, this is the appropriate time. That would be very dangerous.
But doesn't that
so
create,
that is why
doesn't that create space for probably misinterpreting the situations under which a civilian will be tried? Because if you want to make it clear, like they provided for the military stores, you mark the military stores so that we should know.
Yes,
in
that
the
is
law,
why I'm
the
saying
exceptional circumstances.
that is why I'm saying the exceptional situation. That's why I tried to illustrate it with the case of attempted murder. So it brings clearly the military weapon in use of an offense. That is to be exact. Again, in line with this again, making a law for a particular situation. Laws have been made before. My learned friends seem to say that when you mention cattle rustling, you mean Karamoja, and that is wrong because you're making a law for a region. Cattle rustling can be anywhere. Should we first wait to see that cattle rustling had started in Kayonga, then we rush to make the same law? Or make a law which is standard and will be applied universally? By the way, even for a particular case, Karamoja has always had a law which is even more particular than this. Are you aware that there was a Karamoja Act which was providing that if you get any 3 Karamojong walking, or is it 3 or 5?
There were 2.
2 Karamojong walking, the presumption is that they're in breach of the law and should be arrested. Meaning that even if you get full call and a member of parliament in State House, in Entebbe, you can arrest them, or in Makerere University, or in Garden City. Now, this proves that laws are specifically designed to cure a mischief, because at that time there was that demand. So I do not see a wrong in making a law for cattle rustling.
All
in
right.
any case.
I've concluded.
No, for now I can leave at that.
All right. Let's hear from Dr. Sarah Bidete very quickly. And we want to look at the way forward. This law has now been passed. What we're waiting for probably is for President Museveni, who is already saying he's happy with what was done by Parliament to sign it into law, and then it starts working. But
I'm sure next week it will be signed.
it seems there are still disagreements, even across this table, whether there were exceptional circumstances, whether it's constitutional or not. How do we move forward?
For avoidance of doubt, Kenneth, I open the judgment by Chief Justice Olunyidoro, and the advisory orders are from page 195 to 200. The specific, order on exceptional circumstances is on page 199. For the
Page
viewers.
199.
Yeah, for the viewers who might want to read for themselves and the listeners. So I want to read it. Make provision in the UPDF Act for trial of civilians in military courts to be only under limited circumstances and only after the state has concretely demonstrated to the court by verifiable facts and by objective and serious reasons the need and justification for recourse to the military court. This must only apply where, in relation to the specific class or category of persons and offenses in question, ordinarily courts are not in position to undertake such trial. So what are the demonstrable facts that the ordinary courts cannot try murder, cannot try cattle rustling, cannot try possession of guns, cannot, What are the demonstrable facts?
Let me give you an
For example.
Let me give you an example.
No, let me first say.
Let me give you an example,
Okay.
as pointed out by President Yoweri Museveni
Yes.
yesterday. The normal courts are clogged with so many cases. And
So-
therefore,
How about court
So-
martial? His clients are there for 4 years without trial.
and the president said that's enough. That's reason enough.
No.
Mm.
So let me give an example. Before the court martial were declared defunct, the necessary courts. In 2016, the UPDF raids Kasese Kingdom, the Rwenzururu. They claimed to have found guns, pangas, whatever, and they claimed that the Mumbere...
You call it raiding.
Yes.
They called it special operation.
Or whatever. That the Mumbere was planning a rebellion with his guards, which they called the militia. They paraded him with his guards. He didn't War Crimes Division. Why didn't they take him in court martial? He had guns. Of course, we have other examples. Under Jamil Mukuru, they've claimed that was extradition, whatever. So what was the case with Mumbere? If you think these cases are sensible, why didn't you take him to military courts or the 2010
They were
bombings?
convicted
Well,
of the service.
if anybody in possession of a gun is then encroaching on the military stores, why didn't court martial try Katanga murder and other murders? Why? And then what are the special circumstances? And the order says they must be demonstrable beyond reasonable doubt
To who?
in the courts.
So before you
So
trust,
this is the
so you-
the
before-
order. This is the advisory order of Supreme Court. I've read it.
Actually,
Demonstrate in court
Yeah.
before a trial of a civilian
Yeah.
commences.
actually, Sarah,
This is what the ruling says.
if
all
we
right,
were
let's
to
hear
put
from
a-
Doctor.
If we were to put a very, and thank you for reading that, the interpretation is, Kane, you come to my court where George has been arraigned, and you say you can't continue with George because of this reason and this reason. We need George in a court martial. It appears by interpretation that the court sitting must end a verdict
Yes.
after it has been convinced that actually this person
It's
must be
special
taken to the
circumstances.
court martial. But
Are you implying
but-
that before somebody is taken to the court martial,
Yes.
they should be first taken to the Supreme Court?
There should be
Where?
a demonstration in civilian courts. This is what the ruling says. Under G, page 199.
All right.
And if you to take that ruling, you could see that it was anchored on a very interesting international law.
Yeah.
There is that general comment in international law.
Yeah.
Which Professor Naruwairo has put on his Twitter. He says, look, that the Human Rights Committee in General Comment number 32 says that the state party must demonstrate
Yeah.
with regard to the specific class of individuals at issue,
Yes.
that the regular civilian courts are unable to undertake the trials,
Yes.
that other alternative forms of special or high security civilian courts are inadequate to the task, and that recourse to the military courts is unavoidable.
Exactly.
Major, that's why I was saying that the Chief Justice seemed to be saying, look, this is case by case basis. You come, you prove,
Yes.
then we're hands off.
Yes. And there's also another argument that there is required expertise in the military. The military always gives evidence. Expert evidence is
Yes.
given by anybody,
Yes.
including the military.
Yes.
So what stops the military from giving expert evidence in civilian trials
With
where
an
they
expert from
have an interest?
Yeah.
Really, this whole argument is hogwash, a narrative.
All right. Let's move on.
Okay, let's hogwash. Okay, substandard.
Okay.
Yeah.
All right. George, would you like to chip in very quickly, some response?
On the hogwash.
I don't know if
that's
the test of international law.
Of course, the argument which is usually used that, these courts are specialized, the civilian courts are clogged. I can tell you that when the Minister of Children Affairs went and convinced some people that the only way of leaving detention is to plead guilty to bogus charges, and they pleaded guilty, some of whom I was representing, the others who didn't plead guilty, who didn't, even before the 31st January the judgment, had never even appeared in court 4 months later. So I'm telling you that actually, Chitali alone, by 31st January had over 6,000 people, remandees from military courts. So this argument that military justice is swifter is I don't use Sarah's words, but something close to that.
This is under test.
Is under test, to use the academic word. Then the other issue is how, and the bigger issue, how the law-making process in this country has been made a sham of. This bill was laid before Parliament on Tuesday 13th of May at around 1500 hours. The newspapers of that day had carried an advert from the clerk of Parliament saying, people who have any views about this bill, you have up to 14 to submit them. Meanwhile, the views which the advert was collecting had not been, the bill had not been laid before Parliament.
So the views were being solicited before the bill was
laid.
tabled.
That's why I described the whole process as a sham, as perfunctory, and I don't want to use Sarah's word.
But my word is an English word.
Yeah.
Why are you going after it?
I'm not going after it. I'm saying I'm using different. I have a different choice. When they wrote to different stakeholders, including you saw later, including the Law Society, and you know that one of our principal objectives under the Law Society Act is to guide on all of the matters. They later reached the head office of the Law Society at 11:50 a.m. on 14th.
Actually, 55.
No, but the received stamp was 11:50, and they were required to present a memorandum by midday to Parliament. The Secretary General of a political party, at least the NOP, later reached him on Friday at the office, was even on Friday, and was required on 14th, 2 days earlier. When the NRM caucus went on Monday this week, it was delivered on Friday evening, and they were required on 14th. It was delivered on 16th.
It was delivered on the day after it was expected.
The day after it was expected. When the NRM caucus sat on Monday, and I had the resolutions from Honorable Hamson Oboa, he said, we have agreed as a caucus to pass the bill as presented in Parliament by the Attorney General. Meaning the whole process that was going to take place the following day was a sham, was just to rubber stamp. Because the final process, and all the lawyers here know, when the House constitutes into committee stage, it's to debate clause by clause, to be persuaded by what others are saying. But where a caucus sits outside Parliament and says we are going to pass it as presented, then I said, what was the purpose of the lawmaking process? So at the bigger level, Anderson, we need to shine a light on how Parliament has been made a sham, how Parliament has been made a mockery of, that even, I told you that the committee, instead of soliciting views, it was meant to just go through a process. And of course, as clear as it showed, even when they were doing the wrong thing, they did it in a very wrong manner.
All right. I want to stay with you, and you're going to lead us into the discussion of the next phase, where we are looking at another law which was passed touching political parties and conditioning funding to a political party actually engaging in dialogue. Very quickly, give us your quick thoughts.
Of course, that is another. By the way, if you go through the process by which it was passed on Tuesday, on Monday, same story. The Honorable Nakut, representing Napak, sought leave of Parliament to go and bring a private member's bill, and leave was granted. She's such a star legislator that the following day she already had a bill a few hours after getting leave of Parliament. And of course, Anderson, at least you're not a lawyer, but you've covered Parliament substantively.
This is the second time you're saying this matter.
Are you a lawyer?
Might be forced to.
It's a fact. So she's a star legislator that about 6 hours later, she had a prepared bill. This bill is largely targeting NUP. Why? Because NUP is the only party since we went under multipartyism not to engage in IPOD. IPOD has been around for a while. It started as a civil society initiative. And they are saying, one, the Electoral Commission Act already provides for some. It provides for a forum called National Consultative Forum, which is a forum for all registered political parties, where they meet, and they meet quite regularly. The Electoral Commission also mandates the Act political parties to give audited books of accounts. In fact, one of the reasons a party can be deregistered is failure to give audited books of accounts. Now, the Political Parties Organizations Act already mandates political parties to apply democratic principles and all. Now, when they say that if you engage in IPOD, now they are creating another forum for parties in parliament to say that they are making people to talk by force, that you have to dialogue by force. But we can also assess IPOD. How far have we gone with IPOD? What have been the fruits? Because if IPOD had borne a lot of fruits, us as NUP members would have been the first people to tell our leaders, please take us into IPOD, we are missing. I remember around 2020, I think Honorable Ma was the chair of IPOD. He said 2021 we had a number of political prisoners. And he said, in IPOD we are going to engage and say that these political prisoners are released. Then Mr. Basadira took over, my brother. And he also said they had a tete-a-tete with Mr. Museveni in Munyonyo. A picture moment, very beautiful pictures. I don't know what have come out of all those resolutions. So the issue is, every time you think that you have a problem and you legislate in such a narrow manner to target a group, it's ever, and of course, Miss Nakut is just
Honorable
Honorable Nakut from Napak. She's also Miss. She's a lady. Honorable Nakut is just a bearer of something that she's just a Trojan horse. Just like my brother Richard Lumo had made a Trojan horse of some antelope or a bill which died somewhere along the way. She's just a Trojan horse to say that, okay, you...
There's a lawyer who was actually the main draft of that bill. I've forgotten his name. He's called Yusuf Mtembule.
He's a member of parliament.
Yeah, he's the one who actually drafted it, I think.
Yes, I'm talking about the mover. But I'm also discussing substantively that you can't... every time you're bringing an amendment, any good lawyer who knows some bit of legislative drafting knows that the first question would be what mischief or what defect do you intend to cure? What harm is the amendment seeking to achieve? That there's a party which doesn't participate in IPOD, so it's missing out. What defect is that law trying to achieve?
All right. Let's go to to retired Major Wichbola. Very quickly, your thoughts on this particular law.
Now, very quickly, I really have very little to say about that provision, but I will just use bullet points to mention what my friends had said before. Then I mentioned that one. Now, whereas there have been trials before in other courts, trials have been going on, like the case he cited in the Kasese case. But as we said earlier, that over a period of time, with the unclarity of this one being taken to court martial, this one being taken to ordinary courts, and also the appellate provision, which was this appeal is accepted in ordinary court, this appeal is rejected. That is why now the state comes up with a law to clear it. So that confusion of trial here and trial there is why there's this law. Two, there's also a misinterpretation on the provision cited by Sarah. Now, I do not figure out what kind of application will be made in High Court to who will move court. The court martial chairman will come and apply to ordinary court to allow so and so arrested to be taken to court martial. That is ambiguous. The emphasis of the interpretation here is that if you take somebody to court martial, you as the prosecutor should demonstrate to court martial why you have brought that person. What exceptional situation. Not that you, excuse me, I didn't interfere. Let me say this. Not that you first go, maybe there would be an omnibus application in High Court. That court martial, I don't know whether the prosecutor in court martial is going to High Court Criminal Division to apply to have 50 people to be tried in court martial, and then High Court grants, then you move. No. The demonstration here is that the prosecutor should demonstrate in court martial the exceptional situation. Right. Finally, the caucus. The caucus position is, that should not be misinterpreted, is that even the caucus for the opposition sat, okay? The caucus for the opposition also sat that day. So what is wrong with particular caucuses sitting? Now, this caucus was not to kill debate. If there was to be a debate, which was, our caucus position was to debate the position we had reached a consensus on. And opposition caucus also had it. They had decided we shall not boycott, we shall be there, although I later saw them walking out. Now, to the bill, the one you have said. The brief logic in this bill is that we have the National Consultative Forum of 26 parties. I don't know whether this of Semunju now makes it 27 or it becomes 26 parties. That is for all registered political parties. But there is also an organ called IPOD. Now, the double standard our colleagues here want is that when it comes to benefits of iPod, they want it. But if it is said, please be a member. For example, the benefit.
Like which benefits of iPod?
For example, benefit. There is money.
Because what I know,
doesn't come from
the
iPod.
funding that comes to political parties is not from
Attached
iPod.
to iPod.
No.
The money should actually be given to political parties under the auspices of the National Consultative Forum, which is the constitutional body, as reflected in
The
Political
definition
Parties
of
and Other
iPod,
Organizations
the
Act.
definition of iPod are political parties with
Which law creates
representation in
iPod?
parliament.
iPod is an
iPod?
NGO. iPod has been an NGO. It's just being brought into the law right now. iPod has been an NGO.
No, it is started as an
funded
NGO.
by
And
the Netherlands, something, not so long ago.
so, but let me first develop
tea
this.
party.
What I'm saying is, iPod, by definition, are a group of association of members, parties which have representation in parliament.
Agreed.
And therefore, these parties which have representation in parliament benefits, among others, money given by the government through election commission. So we are asking, the government is asking, if you are collectively benefiting from this basket, why don't you then sit to discuss issues about this? Why do you want to dip your hand into the basket, remove the money, but when they said, hey, colleagues, can we talk? You said you don't want. So you choose then to completely abdicate from all. So why do you selectively choose a benefit from that organization? That when it comes from the money, I will put my hand in the basket.
Major,
but when
I
it
think
comes to,
it's not
you
misleading
will have
to
your
say for money
chance.
from an organization.
Council, in a decorum is that when I stand up, you sit down.
But you
When
also
you
know that
stand
in
up, you
debate
sit
we don't
no,
listen to someone.
no.
We
So,
exchange ideas.
therefore, that is the position,
All right.
that you dip your hand in the basket. Please agree to discuss
no
even
iPod
matters about
basket.
this.
So it's
There
a
is no
matter,
iPod
a matter of
basket.
force.
It is not a matter of force. It's just that some members want to selectively behave.
What if I'm
There
not
is no
interested?
basket called
What if
iPod.
I'm not interested in?
I know. I use this as an example.
Yeah.
What if I'm not interested in what is being discussed in iPod? Do you force me?
What is being discussed in iPod? You see,
The
that
constitutional threshold should be I have members in parliament. That's what the law says.
no. You see, the state has to arbitrate society. That is why now, if you think that you don't want, we are 45 million Ugandans, but we can't sit in a National Assembly in Nambole. We sit in Parliament. Then let your view be subjected to a National Assembly to be heard.
All right. Very quickly, Sarah, in 2 minutes, can you sum up your thoughts on this bill?
On iPod, you know, this legislation for iPod is a demonstration of highest levels of ignorance by Parliament and the move of the bill. iPod is an NGO incorporated as a company limited by guarantee, certified and validated by NGO Bureau. How does government legislate for an NGO? Extremely embarrassing. And I hope, George, you are going to strike out this one.
Absolutely.
Let me save the other word. Because the Constitution
Now,
is very
that word is
clear.
now befitting.
Here.
Very befitting.
You know, the Constitution is very clear that NGOs shall retain autonomy as to their work and their objectives. And people cooperate with NGOs on voluntary basis. What business does government have legislating that to everybody you must go to CCG office and sit in their boardroom? What business? Very idle. They don't even understand what is iPod. They don't even, because if they wanted to create a platform for dialogue, let them create it in the law. But to sit and say, now Karamoja community CBO, that everybody must go there. Very idle, very redundant mover of the bill, very ignorant parliament to legislate for activities of an NGO.
Spectrum X on Radio 1 FM. Let's go for a break now. When we return, we'll hear the views of Dr. Nkubi, but also move on to another topic. We'll be looking at the diplomatic relations between Uganda and the European Union in light of some key developments, including one update that we received this particular evening where the German ambassador is actually being accused of supporting subversive activities in our country. Stay tuned to Radio 1 FM 90. We continue after this break.
Spectrum Extra, Fridays 7 to 9 p.m. on Radio 1 FM 90.
Well, we're back on Spectrum Extra live on Radio 1 FM 90. Hearty discussions going on during the break and between members of the panel, and that is Mr. George Musisi, lawyer and member of the National Unity Platform Party, Dr. Sarah Birete, Chief Executive Officer, Center for Constitutional Governance, retired Major Awich Paula Okwil, Director of External Affairs, NRM Secretariat, and Dr. James Nkubi, lawyer, military historian, and expert on military law. Now, very quickly, Dr. Nkubi, let's hear your view on the issue of the political parties' funding being conditioned to dialogue.
I think it's fundamentally flawed as an argument because when you go into the history of the crafting or the our transition to multi-party, the argument of giving money to to parties was that we need to grow them, that we need to grow the multi-party system to emphasize the right of choice, to emphasize the right of assembly, association, diversity of views, for people to be everywhere. The president recently was telling the High Command that people are free to go wherever they want. Now, when you condition money to attendance of a new entity that has now become a statutory body, albeit in contradiction of Article 93, you are practically saying that you are now going against the fundamental foundations that we were using to initially grant money to political parties, because the argument was political parties were struggling, and that it is only incumbent on the current on the state on the government available or ruling to actually extend that help. By the way, that extension, that money that is given to political parties, is Ugandan money. Ugandans are the ones who collect that money, and they say, look, some of us belong here. Can we have that part of that money to grow ideas, to grow parties, to grow youth leagues, to build a robust contestation of ideas in the country, a robust, system where contradictions birth new innovative forms of governance and so forth. Now, when you say that you are conditioning it to attendance, by the way, it's just attendance. Because I think even NUP, if they want, or whichever political parties want, I think attendance does not connote saying anything. I can attend and I listen in, but the fundamental idea is, why should you conscript me into attendance? Why should it be forceful? Which for me, I think it is flawed when you attach access to funds of growth of political parties to attendance of a meeting or an entity in iPod, which already its creation is a contradiction of Article 43. I think it's in bad spirit and contradicts what initially we as a country had decided to do, that we fund political parties for growth, for diversity, to emphasize Article 29 of the Constitution of freedom of choice and assembly. It does not pass the test, and I'm reliably informed by my ADC here that they want to challenge
it quashed.
Yeah.
All right.
And at this point, actually, I think we must appreciate Honorable Dur Jonathan, the spirited fight he put up, which was, by the way, based on law. It was based on law. It was saying, look, we're going into a travesty here. If you want us to begin discussing how we can reconcile, how we can be tolerant, who knows? Maybe you should begin from releasing the political prisoners. Who knows? Maybe you should begin from, other low-laying fruits and not necessarily force dialogue. You can't force dialogue. Nowhere has it worked where you can force dialogue.
And if I may add one
very
thing,
quickly,
you see, if it's for show's sake, NUP can decide to appoint an administrator there who attends and becomes a listening post.
And nothing.
And nothing substantial.
All right.
happens.
Let's get the feedback.
After all, it's a talking shop.
Let me get the feedback coming in from the listeners. I'm going to begin with Kayondo Samuel from Irimba, Luampanga in Akasongola district. Good evening, Radio 1. About the UPDF amendment bill, the wolf has finally convinced the sheep that he's now vegetarian. God save Uganda. Then we have another comment. Good evening, Spectrum Extra. Is money pegged to iPod distributed equally among political parties with representation in Parliament? If so, then the government is right to restrict it only to participating political parties. A comment from Anthony. Good evening, Spectrum Extra. Thanks for the show. In my opinion, it's time we follow the best party in other best party. to make Uganda great among other East African nations. It's time we make NRM a national party because they have all the qualification to carry out the job. Moreover, following the conversation, it seems that all of us have agreed that NRM party is trying to market Uganda to the world. That's a comment from Anthony.
Which program is he listening to?
Isaac listening in from Mutungo. I would like to know from Mr. Awich, in a scenario where the cat rustlers are found with pangas, spears, without any gun or whatsoever connected to the army, whether they will be tried in the military court. Then we have another comment. Henry Chwenda, he says, good evening, Kenneth. Among the 10 commandments, there is one, do not kill. Yet men in uniform are trained to kill. Thought the court-martial is based on army code of conduct, just like a school code of conduct. Anytime rules of procedure in parliament will begin to persecute and imprison MPs for misconduct. Lawrence Laju writes in and says, Anderson, please ask Major Awich Pola to assure us if you won't see the kind of scenario when the army military court is set up, when the army set up many guns in Bobby Wine's room in Arua. Where did the guns go? Archbishop Janan Luwum faced the same problem when guns were assembled to implicate him through the military court martial. He died in the same scheme. That's a comment from Lawrence Laju. George Anwar listening in from Iganga. Good evening, Kenneth and the panelists. Should this bill be signed by the President into law, no employer should fire any employee for wearing sandals to the office because our Black Knights office shoes are now a monopoly of defense forces. We don't want to be taken to military courts. Then Yiga Samuel Mary listening in from Namlondo. Mr. Kenneth, thanks for the show. The only solution to all these sorts of fake laws enacted is to have many opposition MPs. Let the leading opposition aim at that because numbers matter a lot. And another thing, trust me, those legislators who passed it will one time be victims of the court-martial. We have another comment, Anderson and the panel, especially Madame Sarah and our new Kira MP, George Musisi. I totally see our country moving from rule of law to rule by law and full military rule after. I think this is engineered to let citizens lose interest in engaging in the politics of their country so that those in power can rule forever. But we know everything that starts has an end. Lastly but not least, a comment from Richard. I appreciate the panelists for their insightful contribution to this important discussion. Those who argue that civilians should be tried in military courts, I pose the question, why not also emphasize the need for civilians to avoid engaging in actions that would warrant such charges in the first place? It is becoming increasingly clear no thief favors a strong padlock. Often the loudest objections come from those with intention that may disrupt peace and order. Let us ignore the context in which these measures are applied, nor the responsibility of civil individuals to avoid conduct that invites such consequences. Well, we are running out of time very quickly. We will have an opportunity to respond to this comment, but let's move on and look at the issue of the diplomatic corps. The European diplomats had a meeting with General Salem Saleh in Gulu. What transpired there, I think, is common news to common information to most of you. They complained about the activities of General Muhoozi Kainerugaba, the CDF. This particular complaint was emphasized more by the German ambassador to Uganda. And during that meeting, the response they got from Andrew Mwenda was that they had no business, interfering in Ugandan affairs. But we saw Mr. Honorable David Pulkol, who is now an advisor to General Saleh, actually saying, wherever you are in such an office, you cease being a mere individual, you should act responsibly. But what has surprised many people is General Salem Saleh saying that he was apologizing on behalf of General Muhoozi Kainerugaba, but he would not be in charge of what he would post on his X handle in the hours follow. And indeed, Muhoozi did post about this particular meeting and told the diplomats, if you feel squeezed in Uganda, if you're stuck in Uganda, please pack your bags and go. Hours later, we have seen this information coming from the army that the German ambassador has actually been engaging in subversive activities. I want to begin with you, Dr. James Nkobi.
I thought you were going to begin with Major because
I want to begin with you.
That's a great shot of the CDF. No, very interesting developments, which played out before cameras, which was also a very interesting departure from the usual. Again, the resistance by Andrew Mwenda for, valid reasons, but when you test them against our pass and the amount of money that the combined ambassadors who were meeting General Saleh, the amount of money they put in this country. You at fault, or you at a weak point in questioning why they even have a leeway to say what they say. Someone who brings in billions, which you receive quite cautiously, with open hands, and then is attempting to what he thinks is correcting you, you have no moral locus to say that he can't tell you anything, because after all, he's the one who gives you the money. But for me, on a bigger spectrum, I like the fact that this issue, has been taken to the audience of Salem Saleh. I think we get to appreciate how diplomacy sometimes may not yield results if it is formalistic, and the fact that the diplomats chose an office of the leader of Operation Wealth Creation, which in terms of hierarchical acumen in the country sits nowhere. But when they make a recognition that, look, if we're looking at solving an issue and there is power that lies somewhere, we can pursue it. The meeting alone has cemented Salem Saleh and probably the capacity that people see in him as a potential arbitrator between conflicting, caucuses or conflicting ideas within the civil and military relations. Because clearly what the ambassadors seemed to be projecting here was that the civil-military relations in this country are going amok. The way, as they were saying, the CDF, the commentaries is making, and so forth. So we see the cementing of Namunkekera or Guru as a reconciliatory arbitration center. And I think in a country where we are grappling with what next in terms of what we fail all of us to talk about, of transitioning states, when such centers of power begin to emerge and they even attract a diplomatic corps to have a discussion with them, who knows, maybe the gods are signaling that, look, in times of crisis, when you want transition, you may come here. If there are issues in NOP of internal wrangles, maybe there's a signal that you should go to Namunkekera for reconciliation. But for me, it tells a lot about that. But also, General made a very interesting comment, which I think we shouldn't lose track of. He intimated on the transition happening in the military, and the very fact that the CDF currently is a young crop of the new professionals in the UPDF. Historically, the general is right, but also more importantly, and I think we shouldn't lose this point, and why it is key for us to focus here on the military so critically, owing to our history, that all the transitions we have had in this country either have been halted or have been guided by the military. And why we should be interested in what kind of military we have currently is because we can't run away from the fact that world over, militaries play a role when a country is transitioning from one era to the other. But again, only a transitioned military can aid a country to transition. Now, the question that was posed quite vaguely and vainly was, have we seen this transition being completed, that now we can trust the UPDF to guide a similar transition, either politically or otherwise, And so there are all these rumbling questions of international relations, of civil-military relations, of power and influence in this country, all locked up in one meeting. And then, of course, the power of money. We bring in the money. We have an opportunity to. We can say something on what's going on in a country where we are putting money. And I think for me going forward, the fact that we have an opportunity for this to be spoken about in public, for what people are fearing to talk about to come out and be broached to the people that have power in this country. We can't run away. We can't be naive about the overriding power or influence, let me say influence, that General Saleh has for obvious reasons. I mean, and I think history has written
All right.
that these things now were spoken about, the dangers were highlighted. Now we are waiting to see what happened.
All right, George, let's your view on this particular issue of the diplomats and their keen interest. The other day they were at your office, but I know it's part of their ongoing efforts to ensure peaceful, free and fair elections. They have been to all political parties, but this meeting in Gulu.
You know, I had my brother, Dr. James, who is ordinarily a very eloquent communicator, struggling to get very academic words to veer as far away from the basement as possible.
Of course, I reject that. I reject that.
What happened when the diplomats visited? Nope, you saw the tweets coming in saying that they will be expelled, that they will hit the basement, and so on and so forth. Of course, leave alone what the diplomats are doing and what they are not doing. Leave alone, because that is usual. That is their usual. They have always taken a keen interest, and rightly so, given that he who pays the piper pays the tune. But the visit to Gulu is, I think, a realization. And if I'm to marry it with what the first parts of the discussion was that we are increasingly moving towards a military state. We have militarized agriculture. When there's a problem in agriculture, we say we send the army. When there's a problem in immigration, we send the army. When there's a problem in construction, we send the army. Now even in service, judicial, in administration of justice, we send the army. So, but the diplomats going to Gulu to talk about the issues of the CDF, and you know, even in the CDF streets, first of all, from the CDF streets, you can see that he doesn't care much about what the law says. He doesn't care much about any institution. Even when people who are suspects facing courts, he says, I will only release them. He has talked about Dr. VSG and Eddie Mutwe, said, I will only release them to my father. So he says, I is the one holding them, and says, I will only release them to my father. So the diplomats going to the uncle to talk about tweets, I think it's just a stark realization that all these things we call institutions were just posturing. They didn't go to the Minister of Defense, I don't know his name, Mr. Bot. They didn't go to so they went. It's a stark realization that the power runs in the family, and these people, the major powers at their secretariat, this Madame Alupo, this Madame Among, you're just filling up spaces.
All right. Let's hear from you, Dr. Sarah Birete, very quickly on these issues of the diplomats. And then suddenly we get this statement. The person who was vocal in that meeting is involved in subversive activities. That's the ambassador of Germany to Uganda.
Well,
just like the person who was vocal against Amin.
Relations are governed by the Vienna Convention. And they are not limited to a regime. Diplomatic relations are with the people and the institutions of that country. So when the EU meets any other person, people should understand that they're supposed to meet. The diplomatic relations are with Uganda. A nation is defined by three things: territorial boundary, the people, and laws. The military is just one of the pillars of the state. But there is, over-exaggeration, over-importance, overbearing, over-domineering character of the military everywhere, as if they are the most important institution in Uganda. They are not. That's why even the constitution says they should be obedient to civilian authority, meaning the people are superior. So when you see the diplomats, of course they were in Gulu inspecting their projects, and meeting stakeholders is what led them, among other things, to meet with the genocide. But we also know that the genocide also acts as a co-president in this country, with power visible and invisible, and without responsibility and accountability. Very powerful. So when you have such a structure, maybe the ranking of Uganda as internationally needs to be downgraded, Because also the international community has created a problem for us. IMF, World Bank, everywhere praising Uganda as a democratic country, when our democratic credentials are declining every day. So this decline needs to be captured, including what has happened today. Because the ambassador expresses concern. Maybe one would ask and say, why didn't they complain to Ministry of Foreign Affairs? Because that's the line ministry governing diplomatic entities. But also they know that maybe Uganda functions in an abnormal way. And maybe they would have got a solution from individual. Because ideally, if we had a functional democracy, General Saleh would be retired soldier like us, non-state actor. But he wields power.
All right.
So what has happened is that then after talking, which is their right, because I've also seen very weird comments. How do they talk? How? Why are you hosting them? Because there are countries which choose to expel them. So if we think we don't need diplomatic relations, which should be broadly with the people, then we can tell them we don't need them, and then they wind up their presence and go. Other than ridiculing people here, when we welcome them and need them and partner with them. In the last 4 years, EU has spent about 337 euros in development projects in this country.
All right. Very quickly, let's hear from Major Paula Awichi. You'll have the final say on this issue as we come to the
final say with very few minutes. I don't know whether you deliberately put me behind.
Each person has 3 minutes and you exactly have those.
Now, about the meeting in Gulu. First of all, I'm the Director for External Affairs, and therefore part of my mandate is to interface with the foreigners. And indeed, a few months back, the European Union delegation, the entire membership, led by the European Union ambassador, came to the Secretariat, and we had good exchanges. But what I want to assure you is that even when we meet diplomats, by the way, I've been a diplomat for 8 years. I've been in Geneva for 8 years, and I know what it is. Now, we agree in a meeting to have tough talks. And sometimes these tough talks are misinterpreted, but we always have it. And for us, when they met us, we even encourage them to go and meet other parties like NUP. So this engagement keep going on. Now, we live in a civilized nation, and therefore Uganda is not about to say we disengage ourselves from our partners or our friends, because we are just one among the 193 countries in the world, and we have such ratifications of conventions that make us agree to live to that. So let nobody think that we are about to depart from that. One particular comment that came from Saleh that I was really proud about, because I keep telling my friends, even reaching here today, and I keep saying it, that I reach early in a place I'm needed because of the discipline NRA. You know, I grew up in NRA as a baby soldier, as a Kadogo. So I am glad Saleh reiterated that our NRA was disciplined. Now, the task is on the generals, the Saleh, to mentor up the UPDF. Me, sometimes I forget and I call myself NRA instead of UPDF. So it is good that we have to mentor them.
You're just like your chairman who says, you're just like your chairman, Yoweri Kaguta Museveni, who from time to time says, I'm the general of the NRA.
Kenneth,
Yes.
I thought Afande would refer to the remark of genocide. I can apologize, but I don't know why they would tweet tonight.
So now, just last comment is that Sarah hinted on the international community downgrading Uganda for lack of democracy or human rights. But I think we are doing very well. And I keep saying, like, you see the Kenyan lawyer who came to practice here. He came here. But you don't do that in other nearby countries. So I keep telling my friends that, please, the democracy we have here, don't try it in Tanzania. Don't try it somewhere. We'll get yourself out. Here, the Kenyan comes, she's given a practicing certificate, she does her thing. Try it somewhere. So our activists, please remain in Uganda with our democracy.
Time is not our best. We have to
They should not try it in Somalia or DRC,
Let me
right?
thank you, dear.
We are better than
Farage,
Somalia.
for making time to be here with us today.
We are
Let me
better than
thank
DRC.
you, the listeners for
We are better than
tuning in,
Equatorial
for
Guinea.
contributing to this discussion. From me and the
We are
team here
better
in the
than
studio,
Gabon.
we want to wish you a very good weekend. But I do
Don't
encourage
try
you
that in Burundi.
to
We are better
stay
than them.
tuned to Radio 1 FM 90 because we have quality programs
Tanzania, don't try
coming
it in
up.
Tanzania.
From me and the team, we wish you a fabulous weekend.